more. We want to know what these reports the defendant caused the death. Use, I guess, while doing one of these crimes, or while fleeing from one of these crimes. So the response we have is there's not like instructions that there is or clean. 601 people. Sorry. Very helpful. Yeah. Well, the jury's here. They're in the jury room, so we're gonna talk and then we can write something down and just hand it to them. Yes. Yeah. Right, like
Again, you want to think of this what's your next year.
very close to at least the new five. Yeah.
I would probably. Now, so much.
I mean, these will have sometimes I get a lot of questions. And the Hanson's are cases we're going to review. It's kind of a dark Friday because it's. We brought up later on. I was like, all I did is told that you guys went out in the course. Yes, we got there. Yeah. I'm like pretty sure that I can do it. Yeah. Here's another go. These things too, just be random. You know how they happen. Right. So it's samples. We are surprised. Except the judge. Have you ever heard that day? Because a lot of times. Yeah. That's. What things for you? Yeah, well, it was not. There were.
All rise, court is now in session, the Honorable Kevin Hall presiding.
Okay, looks like we've got everyone present. Mr. Weaver, are you, can you hear me? Okay, this is Judge Hall.
I'm here, Your Honor.
Okay, all right, thanks. Where are you?
Zagreb, Croatia.
Okay, all right. Well, the connection works good. I can hear you fine. One moment. Okay, in all three cases, we have all three defendants present, counsel's present, and we have a jury question. I think, did you all receive the question by email Friday? Okay.
Yes.
Yeah.
So you have a chance to review it. Question is, we'd like to know the leads and quote, an immediate flight, unquote, as they pertain to count 8, element 2. So that's the inquiry by the jury, to counsel thoughts on, how you'd like the court to respond.
Your Honor, the state has a proposal. In State v. Brown, 132 Washington 2nd, 529, that's a 1997 case. It was an appeal arguing that the jury should have been provided legal definitions of that. And the court said that it was not necessary. So that it was argued that it was error not to have given them a legal definition.
The definition of what?
Of course and furtherance of. It was a felony murder appeal, so it was directly on point.
Okay.
And the court said, we conclude the phrases, and again, we're talking about the same phrases here, are expressions of common understanding to be given meaning from their common usage. So the state's proposal is to basically give them that these are terms of common understanding to be given meaning from their common usage.
Okay, before I hear from defense counsel, can you say that slowly again, please?
Yes, these are terms
Okay, hang on a second. These are terms, okay.
of common understanding to be given meaning. Sorry.
I don't. I'm not like Ms. Brace. These are terms of common understanding.
To be given meaning.
Given meaning
From their common usage. And again, that instruction wasn't provided. That was a case that was on appeal when the jury hadn't been instructed at it at all. And the court said it was fine that there was no definition because.
Yes, but you're saying that it was error for the court simply to say rely on your instructions. So
No, there was no error in that case. The defendants were convicted. One of the issues on appeal is the defendant argued that there should have been a legal definition provided to the jury, and the Supreme Court held there was no error because technical terms have to be defined like intent.
Gotcha.
But the court has discretion.
Okay.
To provide extra instructions, I guess.
Your Honor, we don't, obviously, the court generally answers these questions by saying you have your instructions. What we'd like, if the court is inclined to do that, to put a blurb at the bottom, that says, words that aren't defined are to be used with their common usage or something akin to what Mr. Backus said.
Okay.
What's the site again?
It's 132nd, Washington 2nd, 529, State v. Brown.
Okay. All right, Mr. Kibbe.
Well, I don't know if we just have a moment to talk amongst ourselves.
Sure. Ms. Weaver, Mr. Kibbe, Ms. Barker, and Mr. Sear are gonna confer amongst themselves.
Okay, I believe Ms. Barker knows my position.
Okay.
Yeah. I think.
All right, thank you. I think that we have a response, a joint response. I believe Ms. Barker is gonna speak for the three of us at this time.
Okay.
Thank you, Your Honor. I think the position of all of the defendants at this point is that the court should give the standard response to a question asking for like an additional explanation of a legal theory. That is just that you have your instructions, you're to rely on them. I think that adding something that you're to give these particular two words their common understanding, or something more broadly to say you're to give undefined words their common understanding. I think it's cleaner for the record, first of all, to just direct them to their instructions. I think everyone's definition of common is different. Each individual person's common understanding of a word is going to be different. So I think that would ultimately cause more potential confusion as to what they're relying on for common. And if one juror thinks one definition is common and another doesn't think it's common, I think that's just another level of definition that's not in the WIPIX. It's going to be potentially problematic. Almost every other single jury instruction the court has given in this case has been according to the pattern instructions, and it wasn't error in Brown not to give a further definition of those, or to give any further definition of how the jury was supposed to interpret those. So I think the court should just direct them to their existing instructions. And I understand the state's position is that the jury may have other questions if we don't direct them that words have their common understanding. But I think that the response of that you're just to look to your jury's instructions will give them enough guidance that the court is basically not going to just define all of the words in every paragraph of the instructions, that they'll get the idea that these aren't the type of questions it's going to be answering.
Yeah, the jury's asking for a legal definition, so I think I would be inclined to say the court is not able to provide a legal definition of these terms, but I'm going to take a look at this Brown case real quick.
And Your Honor, if I can just follow up real quick.
I want to take a look at the case real quick.
Oh, you
Get
want
a chance to
to-
follow up. Yeah, don't
No
worry.
worries.
I want to look at the case before I hear follow up. So hold on one moment. Let me just finish my thought. Sorry. Yeah, just remain seated, folks. I'll be right back.
Mr. Backus, did you want to say about it?
Your Honor, all I was going to indicate is that I don't think it'll be confusing to the jury that if we provide a response just to their question, because it's, I mean, they asked, what do these two terms mean? So if we respond saying, even if these terms are common usage, it's not confusing. Common is used other portions of the WIPIC. And so if jurors disagree, they deliberate on it, which is why they're here.
Okay. Parker, anything else?
Your Honor, I want to first double check that I have Mr. Backus the citation right. It's 132 Washington 2nd, 529.
Yeah, and specifically page 612.
Yeah. Head note 66.
The note 58, I think. Trial courts must define technical words and expressions. Maybe it's contained twice.
I think it goes.
Yeah, 58, thank you.
Yeah.
I think it's head note. Yeah.
Your Honor, I think that the court has properly instructed the jury already on all of the essential elements. So no further instruction should be given based on that case.
Here's what I'd like to do. I'm going to respond. The court is not able to provide a legal definition. That's what they're asking for of these terms. So the court is not able to provide a legal definition of these terms. As such, you may consider these terms based on their common usage and understanding. Ms. Parker, I know you disagree with that, but I think it's appropriate for the jury to at least understand that if terms aren't specifically defined in the instruction, then the common usage of those terms is appropriate. And as Mr. Backus indicates, if there's some debate about what those terms mean, then maybe they can't come to a conclusion as relates to that point. But that's the instruction I'd like to give, and that's what I'm going to provide. Give me a moment so I can want to make sure it's very legible. Okay, so what I've written is, and we can provide this to the jury, the court is not able to provide a legal definition of these terms. As such, you may consider these terms based on their common usage and understanding.
Sounds good, Your Honor.
Maybe not to the defendants, but I think it's an appropriate instruction. So that's what we'll do. Anything else anybody wants to put on the record before we provide that to the jury? And
Nothing from the state.
okay, Ms. Weaver, we're gonna go ahead and go off the record, okay?
Understood.
Thank you.